Well, Joseph Kotrie-Monson is here, Director of Mary Monson Solicitors on Fleet Street. Good afternoon to you, Joseph.
Good afternoon, Sian.
An interesting move by this group of MPs, isn't it? Because they clearly aren't going to let it lie despite that decision.
They're not, and it's breathtaking. Many people would think that the establishment appears to have massively underestimated the extent to which this issue of institutional paedophilia and the word whitewash we've just heard associated with it is not just an issue of anger. It's an election issue. It's something the electorate are seething about. You know, I was just in a taxi and a moderate taxi driver was talking to me about vigilantism, and it wasn't out of any sense of lust for blood. People feel there's no option here because our systems, our justice system, it's apparently not working.
Tell me a little about any precedents that you know of where somebody's been tried in absentia in these kinds of circumstances.
Let me tell you, Sheila, what I haven't heard. In 35 years that our law firm that specialises in serious crime, including sexual offences, has been practising, we have not had a single client on all of these serious cases who has been unfit to plead, for whom that decision was made by a prosecutor in a closed room without public scrutiny. There is a very old principle of justice in this country, Sheila, and that's that justice should be seen to be done.
Tell me what that would look like then in this instance. What would be tested?
Very glad you asked that, because the test of fitness to plead is whether you can give instructions to your lawyers, whether you can understand proceedings, whether you can understand the advice that you're being given by your lawyers so you can act on it, Sheila. This is something that should be scrutinised by a court, pre-trial or otherwise, openly by a judge who shows no favour to any party. There is certainly no precedent that I'm aware of that a decision like that on a matter of this importance, when there is such public attention associated with it, is made behind closed doors.
It's interesting that the Crown Prosecution Service said the case against Lord Janner did pass its evidential test. So there's strong evidence there.
There are multiple allegations over a long period of time.
And accepted failures on the part of the investigators.
There have been multiple investigations over a period of time. There's talk of officers being kiboshed. These are in relation to different children's homes. I'm not saying whether it's true or not, but questions are there that need to be answered. Interestingly, the decision to charge, quite disingenuously, the DPP, Alison Saunders in this case, has said, following advice, a decision was made not to charge. Following advice, as you and I understand it, Sheila, means we took advice and that advice was not to charge. What she meant was chronologically following advice, because the advice that she did have from Ellen Law's QC, respected QC, recommended that Lord Janner be charged. And of course, the most eminent public lawyer in the land, Claire Montgomery, also advised the CPS.
So are you saying she was advised and ignored the advice?
Well, the advice in respect of Claire Montgomery hasn't even been revealed to us. I wonder what it might have been.
Can I ask you as well about the whole issue of defamation? Is it possible to defame Lord Janner in these circumstances? Because I've heard, and I'd ask you to be careful because I'm not sure.
We must talk very theoretically.
Well, I've heard a lot of interviews and read stuff and thought, well, that crosses a line as far as I'm concerned. This is a technical issue, really, but I'm curious about it because of his mental health.
Let me describe what happens if I make a defamatory statement against somebody which isn't true. I say X has done a horrible thing. He sues me. It's up to then, once it's proven that statement is defamatory, once it's proven that I made it, it's actually up to me to prove that what I've said is true. I must justify it by showing it's true. The burden is on me. The problem, of course, in respect of in respect of Lord Janner, is that if he can't give, as he says, instructions to his lawyers in a criminal case, how on earth can he be a competent witness in a civil case? But I must say, the crucial question
is that why we're seeing some rather sort of, an acceptance of guilt?
There's nowhere to run. This case has been decided. The reality is that the police in this case, in an almost, I'm being very, very careful because I don't know what the strength of the evidence is, but I'm saying what the police have said. Police have said this is strong evidence. It's very disquieting. It looks at the moment that unless we have more probity in this situation, there will be one rule for the poor and one rule for the rich when it comes to fitness to plead.
Many thanks, Joseph. Good to see you again.
I'm grateful, Sheila.
Joseph Kotrie-Monson, Director of Mary Monson Solicitors on Fleet Street. Many thanks.